Good evening and warm welcome from the team at Daksha Fellowship to this Daksha Masterclass on Environmental Impact Assessment Draft 2020. It is my pleasure to introduce our speaker for today, Professor Abhishek Chakravarty. Abhishek Chakravarty is an Assistant Professor of Law at SAI University and faculty at Daksha Fellowship. His research interest lies in environmental law and climate change. He has previously worked at the Center for Policy Research, New Delhi, working primarily on water laws and policies in India. He has also worked as a project manager for the European Union on a sustainable development project called EU Switch Asia. He regularly contributes pieces for Wire Science, Live Law, and Down to Earth, particularly in context of environmental law, climate change, and indigenous rights. Before I hand the session over to Professor, I would like to remind you that all participants in this session are on mute, but you can post your questions and queries in the Q&A box, and we'll take them up at the end of the session. You can use the chat box to respond to the polls. With that, I hand over to Professor Abhishek Chakravarty.
Thank you so much, Hemant. And very good evening to everyone who are attending this session. I'm very happy to take this session on 2020 EIA draft notification, upon which I was doing research for quite some time now, since its inception. And so, yeah, I'm Abhishek Chakravarty. I teach at Daksha Fellowship, which is the first fellowship for lawyers in India. So my research interests lie in climate change and environmental law, and something I have also specialized in and I have also worked in. So while preparing for this session and the class and doing research on 2020 draft EIA notification, the internet is flooded with hundreds of articles and pieces, opinions on the draft EIA notification 2020. But I found there are certain loopholes, certain things which they are not explaining. No one is giving a full picture to it. And almost all the articles were highlighting the negative side to it. Of course, it has a lot of negative side, but it also has some positive sides as well. It cannot be totally negative, right? So to begin this session, I would say that in this session, we will make an attempt to assess the policy and reflect on it. So let's basically try to do an EIA of the EIA itself. And before we begin, I want to do a very short poll, a very short question I want to post to you guys. So the question is, do you guys believe that the 2020 draft EIA is a regressive policy? What are your thoughts on that? You can comment as yes, no, even can say and maybe is also allowed. You can write your opinion in the chat box. So then we can move ahead with the session. Okay, so Parthasarathi says yes. Vikram Rana says yes. Varun Kumar says yes. Yeah, Rutuja Patel says maybe. Himanshu Gaur says not fully aware of it. Okay, maybe. Shweta says not completely. Shruti says I think so. Bhargav says can't say. Okay. Yeah, partially, yes. Okay, so yeah. So thank you for your opinions. So let's begin this session. To begin this session, I want to discuss with you guys 3 incidents which happened in last couple of months. And once I describe these incidents, you will be in a position to decide for yourself that how good or bad this draft is, So the first incident is from a village in Upper Assam's Tinsukia district, which is in northeast India. It's a village called Baghjan. Baghjan is a small village surrounded by tea gardens. It has a lot of oil wells in and around it. To the southwest of the village, there is a world famous wetland, which is very famous for migratory birds. It's called Maguri Motapungbil. Towards the west side, there's a small wildlife sanctuary called Bherjan Borajan. And north of the village is a national park come biosphere reserve called Dilution. It's just 1 kilometer away from the village. So what happened in this village of Baghjan, Oil India Limited, which is a PSU, got started drilling oil, and they have quite a lot of oil wells in the village, of which on 27th of May, oil well number 5 started leaking gas. And on June 9th, it caught fire. And the fire was so huge, so big, that it engulfed the entire village. The entire village was razed down into ashes, completely destroyed. Over 9,000 people became homeless. And there was oil spill all across, in the neighboring agricultural fields. The tea gardens were destroyed. There were carcasses of river dolphins found. A lot of animals died. The entire ecology was hampered because of that oil spill and the subsequent fire. And till this date, it's been almost 2 months now, this has been going on. The fire is still burning, and it can be seen from as far as 25 kilometers away. So the question is, what was wrong with this project? What was wrong with Baghjan? The point is, an expert committee which was appointed by NGT recently under Justice B.K. Kotoki, who is a former judge of Guwahati High Court, it revealed that Oil India Limited did not have prior environmental clearance. Oil India Limited did not have prior consent from Pollution Control Board of Assam. Also, the Supreme Court of India ordered oil in 2017 to carry out biodiversity impact assessment. That was also not done. So you see the number of lapses which the PSU did, and because of these lapses, such a disastrous incident happened. And coming to the second incident, it's from South India, Vishakhapatnam. It's the famous Vizag gas leak case at LG Polymers plant. So similarly, the plant here was also operating without environmental clearance. They were supposed to get one within next few months, but they were doing without they were operating without an environmental clearance for nearly 2 decades. It's a huge time. And this incident could have been the next Bhopal gas tragedy, but luckily it didn't become that big, and still 12 people died, over 500 people were hospitalized. And these are the small lapses which we see, and the small loopholes in our EIA system which has led to this. And the third incident is again from Northeast, the national park which I told you about, Dilution, which is also a biosphere reserve. We in India have a handful of biosphere reserves, 12 or 15, which are of huge biodiversity and ecological importance. And this year in May itself, government gave clearance to 7 oil wells, oil drilling inside the national park, not around it, not in the eco-sensitive zone, but inside the national park. And there was no public participation in the EIA. And when the expert appraisal committee was questioned why there was no public participation, why was it given a environmental clearance, they said it's because of national interest. Now the question is, how do you calculate national interest, right? I mean, on one side you have a biodiversity hotspot, on one side you have oil. I think biodiversity hotspot is of equal importance to nature, to the country. It's of equal it has equal national importance. But the MOEFCC decided to go ahead with the environmental clearance. So these 3 incidents point towards only one thing, that even our existing environmental norms, most particularly the EIA process, is already very weak and has several loopholes to it. And because of that, it allows PSUs like Oil India or companies like LG Polymers to bypass it and run without environmental clearances. Now, my moot question is that should we allow further weakening of an already weak system through this draft 2020 EIA? I mean, it's already a weak system. Should we further weaken it? My answer would be absolutely no. We should actually strengthen the EIA regime. And you can give your own views in the chat box. What do you think? Should we further allow the weakening of this EIA or should we strengthen it? Coming to the next part. So the next 3 slides, I'll yeah. So coming to the next part. So the next 3 slides, I'll be discussing what EIA basically is, its evolution, and the steps of EIA, the process, the entire process of EIA. I mean, for a lot of you, it might be very basics, but a lot of my friends have called me up over the last few days who are now working in law firms, who have an experience of 4 or 5 years, but still they are unaware of the entire process of EIA. So for those people, kindly bear with me for a few minutes. I'll give a brief description of the EIA process. So first of all, what is EIA? EIA is basically a study or a process through which, the consequences of a development project or an industrial project on the environment can be identified. It also acts as a decision-making tool wherein, because of the study, the entire information about the area, the various consequences, the various alternatives of a project, and how to, how to go on with the mitigation strategies. All those things can be brought in. And the best part about EIA is that even before commencing the project, you get to know how the project, how the project will impact the environment, its adverse impacts. You can plan the mitigation way ahead. And it has shown its benefit in many cases. And another important part of it is public participation. Because of public participation, there has been less conflicts. Many a times when we do not take, public's consent and opinions from the public, there are a lot of conflicts which happen. I mean, even in the Baghjan oil leak case, we see that the public is protesting a lot because their opinions were not taken while giving the environmental clearance. And therefore, EIA has these benefits, and it leads to protection of environment, optimum utilization of resources, and also saves time and cost for the project. And coming to the next part, the evolution of the EIA mechanism in India. So EIA as a concept began in the United States in 1960s, in 1969 precisely. But in India, we see this process begin in 1977, 1978, when the Planning Commission asked the Department of Science and Technology to examine river valley projects from an environmental angle. So thereafter, in 1994, the Ministry of Environment and Forest, the way it was called then, unlike now it's called MOEFCC, under the Environment Protection Act 1986, promulgated an EIA notification making environmental clearance mandatory for expansion or modernization or any activity or for setting up new projects in Schedule 1 of the notification. Since then, since 1994 to 2006, we have had around 12 amendments to the EIA. Mostly, they try to, most of them were attempt to ease out the EIA regulations. But again, in 2006, a new notification was brought out, which actually, made it quite strong and brought in various projects like mining, thermal power plants, river valley infrastructure projects like highways, ports, harbors, airports, and even small chemical industries and foundry units under the ambit of EIA. So all these developmental projects, industries had to have an environmental clearance. But from 2006 to 2020, again, we observe that the entire EIA process is tried to be weakened, weaken its provisions. There have been several amendments. In fact, this year in January, what happened? Oil exploration projects, both onshore and offshore projects, were brought into something called a B2 category. So in 2006 notification, we have projects under the heads of A category, B1 category, and B2 category. So B2 category are those which are the least harmful to the environment. But earlier this year, even oil exploration projects were brought into B2 category. And today we see the harsh impact of this decision in Baghjan case, where oil well spill has destroyed an entire village. Even a few days back, there was another pipeline blast in Assam, which goes unreported in the national media. It has also had its own impact on the local biodiversity. So now coming to the EIA process. So let us try to understand what the process is. So there are a few steps which are being followed. And the process, in fact, takes an entire year, which is true. It takes a lot of time because it's a step-by-step process where everything is considered. So the first step is screening, wherein the project is screened for the scale of investment, the location, the type of development, and then put into categories A, B1, B2. Certain categories do not require EIA, so they are passed and allowed to be established. And for the other, there's scoping done, wherein issues concerned with the area, proper identification of the area, if there are alternatives to the project, those things are discussed. And the scoping allows, baseline data collection to take place. After the baseline data is collected, then we move ahead with the impact prediction. The impact prediction is almost like a basic EIA report minus the public consultation. So this report includes project site data, demographic information, ecological diversity data, actions and steps for preventing, minimizing, or passing the impacts, or else the level of compensation for probable environmental damage or loss. And this is followed by a public hearing wherein all the stakeholders who are going to be impacted by the EIA, including the local people, the district administration, forest department, panchayat, everyone is brought in together where they deliberate, they discuss. A villager who is, suppose he has an agricultural field near a possible thermal power plant. So he has the right to know what this power plant would have, what impact this power plant would have on him. So this is done through the public hearing process, and they raise all their concerns, and it's a very important step in the EIA process. If you do not follow it, if this is not followed, what happens? I mean, tomorrow a thermal power plant is built, let's say, and the thermal power plant somehow pollutes the neighboring agricultural field. Then of course there'll be a lot of protests, there might be conflicts, and we have seen such situations. I mean, across India, there was this Tata plant which was, which was supposed to be there in West Bengal, and because of a lot of public protest, it did not come up. And similar, there's this Subansiri Dam over a river flowing from Arunachal to Assam, a Himalayan river. The dam took over 20-30 years because of years of public protest because public consultation was not done. Without public's consent, the project was taken forward. So this is a very important step in the EIA process itself. And after the opinions are recorded, the environment management plan is prepared, which is called the EMP. And all these things together combine the EIA report. This report is submitted before the MOEFCC, and then the decision making happens. They might reject it, they might accept it, and if it is accepted and given a clearance, then the clearance is to be monitored. So the industries need to give a compliance report every 6 months. So it's an entire mechanism which makes sure that the environment is not impacted and not adversely impacted, and along with development, we have protection of environment as well, going hand in hand. Basically promotes the concept of sustainable development. So now coming to the most controversial part of the topic and the most contentious issue is the EIA 2020 EIA draft notification. So while reading about it, as I said, I mean, trust me, I have not found a single article talking about the positive aspects of this draft, but I still will make it a point to highlight some of the positive things which I have seen, at least while concluding, because it's very important to know the pros and cons of everything as lawyers. Otherwise, we wouldn't have the complete picture before ourselves, and we would only have the half truth. No matter how unbiased I try to be, very frankly, if I am to put it, I find that this policy is regressive, because especially at a time when the world around us is speaking about environmental issues, highlighting the issue of climate change, and climate change is in fact impacting us. In fact, COVID-19 itself is a zoonotic disease, which happened because, in a way, a lot of people say because of illegal wildlife trade from pangolin, it spread into human beings. That's one of the theories. So because of environmental issues and climate change issues, I mean, our world has been affected a lot, and it's a major concern. Even our own country, we make a lot of big promises and pledges in a lot of international environmental summits. If we look into our intended nationally determined contributions, which we pledge at the Paris Agreement, we promise to reduce our carbon emissions by nearly 35%. But at home, we are bringing in drafts like this, which would help industries to pollute instead of protecting the environment. We are auctioning off coal. We are building dams. In fact, 169 dams have been proposed in Arunachal Pradesh, in a small state in Northeast, 169 dams. And as a result of these dams, the Himalayan rivers are dying, and it's going to be catastrophic. And after reading the draft well, I find basically 4 primary contentions. And a lot of people have spoken a lot about this draft in a negative way, but I think there are 4 major contentions which needs to be discussed. So the first is dilution of public participation. So since 1700s, be it in French Revolution or Swedish Royal Order, we see that public participation in decision making has always been emphasized and given importance. Especially the concept of republic or democracy stems out from the people itself. Even in the environmental arena, we see that the Brundtland Report in 1987, the Convention on Environment Impact Assessment in Transboundary Context in 1991, Rio Declaration and Agenda 21 in 1992, all give priority to public participation. In US, they give 45 days of time for public comments on draft EIA. in many European countries, they give almost a time period of over 2 months for public comments on EIA, on any kind of an EIA, And in India, we see that the draft EIA notification reduces the time period of receiving public response from 30 to 20 days in projects where public participation is intended, particularly A category and B1 category projects. And again, this draft itself says that in case of B2 category projects, there shall be no public participation, no public hearing. So basically, B2 category projects are projects like mining in less than 5 hectares of land. And but the problem is that what kind of mining they have not specified. It can be radioactive minerals like uranium. It can be a lot of dangerous mining projects which might happen. And if it does not have public participation, it can be disastrous. Then oil exploration projects don't need public participation. Dams up to 25 megawatts, small and medium scale cement plants. Cement plants actually impact the local environment a lot. A few years back, I was involved in this research wherein a medium-sized cement plant was established near a wildlife sanctuary. It's called Pobidara Wildlife Sanctuary, which is home to Indian one-horned rhinoceros. In fact, it has the highest density of Indian one-horned rhinoceros. So the government somehow, the company itself somehow got a clearance and established a medium-scale cement factory very close in the eco-sensitive zone of the wildlife sanctuary. And over the years, we have seen its disastrous impact on the wildlife sanctuary itself. It used to be a wildlife corridor, especially in flood seasons, and the animals have moved away. And they do not use that corridor anymore, and it has harmed the animals a lot during the flood season. And if we do not allow public participation, if we give environmental clearance to B2 category projects, especially small and medium scale cement factories or oil explorations, it can be very detrimental to the environment. And also we see that in B2 category, they have put in micro, small and medium synthetic rubber and even chemical industries. Expansion and widening of highways. A lot of highways pass through these protected areas through a lot of forests. Then inland waterways, building projects up to 150,000 square kilometers. No public hearing is required. And another contentious issue is in case of border areas, if you see according to this draft, includes 100 kilometers away from the border, the entire area. From the border to 100 kilometers away, the entire area is considered border area. If we consider that, whole of Northeast and most of the Himalayan region in India would fall under the border area category. So in these regions, which are highly eco-sensitive, which has a lot of biodiversity, if you do not allow public participation, if you give direct clearance to such projects, it can be really detrimental to the environment, especially in these eco-sensitive zones. And another thing which I feel is the most draconian in case of public participation is that according to this draft, citizens cannot raise complaints in case of non-compliance with the environmental clearance condition. So only the project proponents, basically the project owners or the management and the government can make cognizable complaints if an industry is violating environmental clearance norms. And it's actually funny, which I feel, because which industry would actually come up suo moto and say that I am polluting, I am not complying with my EC environmental clearance conditions, and would highlight and make a complaint against itself. It's absolutely a joke. And in Samarth Trust case, we see the Delhi High Court itself clearly highlighted the importance of public hearing, stating that a public hearing is a form of participatory justice, giving a voice to the voiceless and a place and occasion to them to express their views with regard, views and with regard to a project. And such a public hearing gives an opportunity to the people to raise issues pertaining to social impact and health impact of a proposed project. In fact, in Lafarge uranium case, the Supreme Court also says that if you do not conduct a public hearing in such a project, it's against Article 21, right to life under Article 21. The Gujarat High Court also emphasized a lot on public hearing in the case of Center for Social Justice versus Union of India, and also has insisted on a minimum of 30 days for public hearing. Right. So public hearing is actually one of the primary things, essential part of environmental, protection and the EIA process. And doing away with it, I think, is a very regressive step, especially on part of this draft EIA notification. And my next contention is that the ex post facto clearance. So the fundamental purpose of EIA is to evaluate environmental soundness of any project. So this is the essence of the EIA. And if you allow ex post facto clearance, you are diluting the essence of EIA. We have seen consequences of ex post facto clearance in Vizag gas leak case, where without doing an EIA, they had given an environmental clearance. We have seen it in Baghjan case, where they had given an environmental clearance without EIA or public participation, and its consequences. In fact, in April this year, the Supreme Court itself said in Albemic Pharmaceuticals versus Rohit Prajapati case that ex post facto clearances are and in 2017 the same Honorable Supreme Court gave judgment on similar lines in Common Cause versus Union of India. In 2013, Association for Environmental Protection versus State of Kerala, the Supreme Court held that commencement of project without obtaining environmental clearance is violative of fundamental right to life guaranteed under Article 21 of the Constitution. And we have so many judgments which have criticized ex post facto clearance. Then what was the need of bringing it in the draft itself? That's my question. And the third contention is that right now there are a lot of industries which do not require EIA under the draft, particularly the B2 category industries which I discussed, oil exploration, expansion of highways and etc., would not only not require public consultation, but no EIA itself. All they need to do is submit a environment management plan, which is a small document giving basic information about the project. And this is actually in contravention to a lot of our international obligations, be it under Convention on Biodiversity or United Nations Framework Convention on Climate Change, or even our INDCs under the Paris Agreement, and many more. All emphasize on EIA, they mandate EIA for development projects and setting up of industries. It is also in contravention to many of our Supreme Court judgments and many of our basic environmental jurisprudence. Like in Vellore Citizen Forum, the Supreme Court clearly emphasized on the need for, environmental law principles like precautionary principle and sustainable development principle. This clearly contravenes that. It contravenes the public trust doctrine. And therefore, it really doesn't make sense. You try to violate, coming up from an environment emanating from Section 3 of Environment Protection Act, if this draft tries to go against all the basic environmental jurisprudence of this country, I feel it's violating a lot of our norms. And the fourth is that it will lead to monetization of environmental violation. So the draft absurdly commodifies environmental damage, and which are to be countered with monetary compensation. So tomorrow, if an industry which has to submit a compliance report, if it fails to do that, it needs to pay rupees 500 for if it falls under B2 category of project, rupees 1000 if it falls under B1 category of project, and rupees 2500 if it falls under A category of project per day. So suppose tomorrow a oil and gas exploration project which falls under B2 category fails to comply with compliance reporting every 6 months, it has to pay around 1,82,500 rupees every year. So for a oil and gas industry which is earning in millions, 1,82,500 is nothing. So a $1 million company goes away by paying a minuscule amount and keeps on violating the norms. And under this draft, they can do so. They can keep on paying fines for up to 3 years. After that, their environmental clearance certificate would be cancelled. So for 3 years, they can pay merely 1,82,500 and keep on violating the environmental norms. Basically, this is a monetization of environmental violations. And industries would keep violating. And besides these contentions, there are also other things which I see that compliance report earlier was required once in every 6 months, and now it will be required once in every year. So from 6 months, it has been extended to a year. So only once in every year you need to give your compliance report. It has increased the validity of environmental clearance for mining projects from 30 years to 50 years. So once a clearance is given to say a coal mine, the clearance is valid for the next 50 years. And for river valley projects from existing 10 years to 15 years. Again, coming to the baseline data, the contention is that baseline data would only be collected for one season. Now, if we take an example of a wetland, suppose Bharatpur Bird Sanctuary. So a wetland like Bharatpur Bird Sanctuary usually gives refuge to birds during the winter season. Migratory birds come into India during winter season. So in summer season, you would hardly find any birds there. But if you do a baseline collection during summer, you'll find no birds, and the environmental clearance will be very easy. And that way, a lot of these industries can come up near any bird sanctuary, any wetland, any eco-sensitive zone by just collecting baseline data in seasons where there are no animals. And likewise, Now in the light of the above contentions, we see that there are several legal concerns which are arising out of the new draft, many of which I have already discussed, but I would still like to throw light up on them separately. And the first is the EIA notification is issued under Section 3 of Environment Protection Act. So the main essence of this act is environmental protection. Section 3 itself makes it necessary for, it's a statutory requirement, and which for anything under Section 3 has to fulfill the purpose of protecting and improving the quality of environment and preventing, controlling, and abating environmental pollution. In fact, the Supreme Court has also said this year in April in the Albemic pharmaceutical case. And this draft is absolutely contrary to this section. And as I already put it, it's against the basic environmental jurisprudence of this country, be it precautionary principle, intergenerational equity, polluters pay, or public trust. And post facto clearance, project clearance and exemptions from EIA violates all these principles. And these principles have been made a part of our law of our land and is there in in many of our, legislations. In fact, in the NGT Act itself. And it's a clear violation of these principles. And the draft is also in non-conformity to many of our international obligations. I mean, at one point of time, we were seen as a strong player in environment negotiations and all the environmental conventions, and everywhere. We are a signatory to almost all of these international conventions, CBD, Rio Declaration, UNFCCC, Paris Agreement, and so on. But if we emphasize, if we bring in something like this, we are, like this draft EI report, we are in total contravention to this international conventions. And also finally, our constitution has 3 provisions, Article 48A, 51G, and Article 21, wherein right to healthy environment, wherein protection of environment, duty to protect environment to citizen, DPSP on part of the government is being highlighted. And if we pass something like this, the draft notification, we will be totally in contravention to these provisions. And I think if it is challenged, I think this case would actually has a chance of, getting through. And coming to the judgments, which are contrary to the 2020 draft EIA notifications, as we already discussed, the Albemic Pharmaceuticals versus Rohit Prajapati, Common Cause versus Union of India, all of these have condemned ex post facto clearance and struck them down. Then Association for Environment Protection versus State of Kerala even went on to declare projects without environmental clearance as violative to right to life under Article 21. Then the Honorable Supreme Court in Lafarge, Umium Mining Private Limited versus Union of India held that a public consultation is a mandatory requirement of environmental clearance process in providing an effective forum for any person aggrieved by any aspect of any project to register and seek redressal of their grievances. The Samaj Trust case also reiterates on the same fact on the importance of public participation. The Vellore Citizen Welfare Forum case also, puts emphasis on sustainable development, precautionary principle, and it has brought in these principles into the environmental jurisprudence of this country, into our domestic legal framework. Majdoor Kisan Ekta Sangathan versus Union of India said that public consultation is very important for any development project as it directly impacts them. Similarly, we have this, celebrated case of Subhash Kumar versus Union of India, wherein the right to healthy environment was put under right to life under Article 21 of Indian Constitution. In fact, the ICJ in the case of Costa Rica versus Nicaragua highlighted the importance of public participation and said, Justice Dalbir Bhandari from India was the judge in this case. He said that EIA process as a whole is a very exemplary process and it needs to be followed in case of any developmental project. Now, coming to the economic and developmental concerns, I really wanted to highlight these issues because, first of all, the government wants to depict that the draft EIA is an enabler of ease of doing business and economic growth booster. And also that very few people are talking about this, about the economic and developmental concerns of the EIA. My first issue is that the government has not taken into account environmental costs which might come up due to the loopholes in such regulations. I mean, in Baghjan oil well leak case, we see that because of the oil spill, the agricultural fields have been destroyed, tea gardens have been destroyed, the local ecotourism industry has been destroyed, so many houses have been turned into ashes. The entire gas reserve is burning for last 66 days. And if we calculate and also NGT has ordered Oil India Limited to pay a compensation of rupees 25 lakhs to the affected. If we calculate all these, environmental costs, it far outweighs the economic benefits arising out of this project. And this has all happened because of lack of environmental safety and non-compliance and loopholes in the EIA regime, existing EIA regime. If we further weaken it, environmental costs would keep on increasing. In fact, I was reading a research paper recently, published in the journal Nature Communications, where it is estimated that the environmental costs out of climate change in next 80 years would be 1 quadrillion, which is like over 1,000 times the cost we had to bear because of the COVID pandemic. So environmental cost is a huge issue, and it's more of an economic concern. And I feel the draft EIA will further add to it. And next is that many institutions like ADB and World Bank do not issue loans to projects without EIA. Recently, it makes me happy and proud that we in India inaugurated the largest solar power project in Madhya Pradesh, the largest in Asia, which was funded by World Bank. But once we put, the new draft EIA puts solar power projects out of its ambit. And if we do so, institutions like World Bank would refuse to finance those. Then at a time when the world over has accepted sustainable development goals, we have ingrained it in our own jurisprudence. We have international commitments like UNDP's sustainable development goals. We cannot be so regressive with our policies. We might face economic loss on other accounts, like we might face loss on healthcare accounts because of environmental issues. If tomorrow we have another pandemic because of climate change, if viruses from polar ice caps melt and come out, we might have health concerns. And from an economical perspective, this doesn't make sense. If we need for small benefits out of developmental projects and industries, if we have to bear a huge environmental cost later on, it doesn't make sense at all to me. And the last point which I want to highlight is that we must do away with the bureaucratic and political red tapeism which exists, which actually do not allow, which are the primary hurdles in the way of ease of doing business. While I was working for European Union, I was doing consulting work for a lot of sustainable and green industries in Northeast. And that point I saw for even a green industry, for even a non-polluting industry, to get an electricity connection, it takes almost a year. See the bureaucratic red tapeism. To get clearances and permissions from district industry center, it takes several months. So if we could ease these things, I believe our purpose should have been to ease these issues first, and which would have led to the growth in the economy without harming the environment. Right. And I think these should be done away with, the bureaucratic and the political red tapeism, instead of the EIA regime. And finally, to conclude, I would like to take a moment to highlight the positive aspects of the draft. Although I did not find many, but there are a few positive aspects which I found. First is quick appraisal. It is true that the EIA process itself takes a year. Environmental clearance takes a year, which is a long time. And this draft allows quick appraisal and allows quick granting of environmental clearance. And it has also given relaxations to micro, medium, and small enterprises, which are the backbone of our economy. A lot of people in India depend on these enterprises, and allowing easy setting up of these institutions would be helpful in a way. Plus, putting small irrigation projects under the B2 category will prove as an impetus to the agricultural sector. It also helps in establishing a small special economic zones by putting those under B2 category. And EIA process has also been decentralized, and state and union territory level environment impact assessment authorities have been established, are planned to be established. So there are certainly a few positive aspects which I would not disagree. But the only thing is that all these positive things which we see can only be welcomed from a industrial point of view. But from an environmental point of view, it's very regressive. So something like EIA, which was brought in to protect the environment, if it becomes pro-industry and anti-environment, it's absolutely making no sense. And therefore it depends on, at the end, I would like to say that it depends on from what perspective you look at it. If you look at it from an industrial perspective, yeah, it might give you some initial gains. But from an environmental perspective, it's really detrimental and harmful. Like, we are allowing industries to pollute the environment and then pay a mere fine and go away with it. And so to conclude, I would like to say that, from my own point of view, from an environmental perspective, as an environmentalist, as an academician, if I look at the draft, it's a very regressive policy from my end. And I hope this session gave you a clear picture of the EIA process, the draft EIA, and the probable consequences. And now I shall move on to take the questions. So coming to the questions, the first question is from Amrit Sharma. Do you think NGT is working efficiently in India? Yeah, I have been following a lot of NGT judgments. In a lot of cases, they have been working efficiently. There was this case in Kaziranga National Park, which is in Assam, where I saw that in Kaziranga National Park, there were stone quarryings around the national park, which was hampering animal movement, was hampering animal corridors. So NGT took a very big step in stopping those stone quarries. Then in another refinery case, a refinery built a wall in an animal corridor, and which stopped elephants from migrating. So NGT took a step and addressed this issue as well. And coming to the next question, as per the draft, this is from Shruti S. Balakrishnan. As per the 2020 draft, are NGOs allowed to raise complaints in case of EC non-compliance? No, absolutely not. Only the government and the project proponents can raise complaints in case of non-compliance. Then there's an anonymous attendee who's asking, in Vizag gas leak tragedy, which is analogy of Bhopal gas leak tragedy, both are running by international companies. Despite huge gap in tragedy between these same environmental hazards repeated, why the environmental clearance and audit it passed to establish these companies in India, taking lives of so many people besides so many remedies? When incident happened, then only they draft the new policy. Yeah, I feel that there are remedies available. That's true, but there are still a lot of loopholes. And like here in this case, environmental clearance was given, and this is only because of the loopholes that the government or these industries try to bypass this. And Okay. What about Indian banks granting loans on EIA report? Well, I do not have an idea about Indian banks granting loan without EIA report. I'm sorry, I wouldn't be in a position to answer that. What can we do as citizens? Well, we can actually, there is a portal opened by the government. Tanvir, I asked, what can we do as citizens? There's a portal opened by the government where we can send in our views regarding what are our thoughts about the EIA. There is still time till somewhere around mid of August, and I think you guys should actually, uh, give your views as soon as possible. And anonymous attendee, how do you think courts have viewed this idea of national interest where it harms human rights group of people for the betterment of larger? Yeah, I mean, it's of a different context, but still I would like to answer this national interest. The idea of national interest itself is very contentious. I mean, how do you view it? I mean, is the concept of nation above the people who form the nation itself? I have this question, are people above the concept of nation? If something harms the people, if something harms your environment, if something harms your country, how do you term it as national interest? I mean, if you allow oil wells in a biodiversity rich area and it destroys your biodiversity, it destroys the environment for the future generations, how do you call it national interest? Then Suresh says, since the MOEFCC is a government body, is there an independent body in the process which keeps MOEFCC accountable in this process? There's an expert appraisal committee called the EAC. It is a part of the the EIA process. It does not keep the MOEFCC accountable, but it can give certain advice to the MOEFCC whether to grant clearance or not. Usually, if the EAC says that do not grant clearance, MOEFCC does not act contrary to it. And then we again have our our judicial ways of going to courts, and which can keep track of the processes done by the MOEFCC. Next is, where do we go from here? Is the government seen to be accepting of the opposition? I think if we all, I mean, a lot of student groups in Tamil Nadu are protesting. Students group across the country are protesting. There have been Twitter storms. I have been a part of a lot of those, initiating these campaigns against the new EIA. If we keep on doing it, if we keep on pressurizing it, it's for our own future. If we do not do it right now, our own future is at stake. Then Kanishk Wagwase said, is it possible that the present pandemic could be a consequence of environmental imbalance? Not exactly, but yeah, because of the present, pandemic, a lot of very controversial such drafts are being tried to be passed because there's a lot of lockdown. People are more concerned with the pandemic. And taking this situation, if they pass something like the draft EIA, I mean, God save us in the future. What are your, Meher Nigar ask, what are your perspective about Amazon fires? In case of those fires, compared Amazon rainforest bigger, how is it? Yeah, I mean, Amazon fires are really dangerous. I mean, Amazon, if it actually, rainforest take in nearly, some say around 20% of the carbon dioxide from our atmosphere. And if Amazon rainforest is destroyed, it will be really disastrous. There'll be a lot of CO2 in the atmosphere. Global warming will speed up a lot. Polar ice caps will melt, and we all know the consequences of water level rise and everything. And in fact, I would like to let you know that there are rainforests in India as well, which we have not given importance. There are rainforests in Assam. In Assam, there's a rainforest called Dihing Patkai, which is known as Amazon of the East. It's a huge rainforest, and the government had recently allowed coal mining in a part of the rainforest. There had been a lot of public protest. There had been PILs. Now NGT has formed a committee to look into the matter. Somehow Coal India Limited has agreed to suspend its mining operation, but it's inside a rainforest, the Amazon of the East in India. I think we have taken enough questions.
Yeah, Professor, that was where I was coming to. We have sort of run out of our scheduled time. Do you want to take a couple of more questions, or should we call an end to the session?
I think we can. I mean, they can email if they have more questions. Let me share my email ID. I'm sharing my personal email ID and the chat box itself. So if you have any questions, if I missed any questions, I'm really sorry. We had this 1 hour's time. We can continue this similar session, next session on something on similar topic. We can also discuss it then. Kindly email it. If you have any questions, kindly email it. I have shared my email ID with you guys. I think.
Sure. So thank you, Professor, for this very wonderful, informative and very passionate talk. Our thanks to everyone who took time to attend the session. For all the students attending today's session, our final round of application is in progress. We look forward to having your application for the Daksha Fellowship. If you have any additional questions, do reach out to us through the contact us form on our website, www.dakshafellowship.org, or by phone through 9940057400. With this, we come to an end to the session. Thank you so much.
Thank you so much, everyone.